Hello, and thank you very much for joining us today. My name is Ian Scott, and I am the founder of Scott Legal. Today, we're going to spend some time talking about the National Interest Waiver Green Card, and this is also known as the NIW. This is an underutilized category and one that we started to see more and more people start to use to get green cards, in particular in the entrepreneur category. And we're going to go over this in more detail. A few things before we get started. The firm is a full service immigration law firm, and we focus on a number of different types of immigration petitions, including the NIW category. We will continue to uh, put together webinars, and we will have at least 2 webinars every month on different topics. And a few things that we're going to send to you after this webinar. One is we're going to send you a copy of the PowerPoint presentation. Second, we're going to send you a National Interest Waiver guide. So this guide is a comprehensive guide that has a lot of the information that we're going to talk about today. And then finally, we're going to send you a link where you can sign up for additional webinars. In terms of our panelists today, we're lucky to have Kelly Legrand-Wiener, who's the managing attorney of the firm, and Michaela Brazdova, who's an associate at the firm. Both of them have vast experience processing a number of different types of visas, including the National Interest Waiver. My name is Ian Scott. Again, I'm the founder, and I'll be the moderator. You can add questions as the webinar continues in the chat box or in the question and answer box, and we will get to all questions, and some questions have come in advance as well. And finally, the webinar will be recorded and made available on demand. So without further delay, we will turn it over to Kelly and Michaela.
Thank you, Ian. So we're going to get started by discussing the national interest waiver requirements, going over those threshold requirements and how you qualify for the waiver. And before we get into that, I just want to specify that the national interest waiver is available under what's called the EB2 green card category. This is a category where normally you qualify by having an advanced degree or exceptional ability, and then you can be sponsored by a US employer. So that means you need a job offer. So what the National Interest Waiver allows you to do is it waives that requirement of the job offer, and it waives the requirement of something called a labor certification, where your US employer would have to test the labor market to see if there's any US workers available. So that's the benefit of the waiver, is that although it's still in this EB2 category, you don't need a job offer from a US employer, and you don't have to go through that labor certification process. So with that, let's get into the actual requirements. So part of the EB2 category, a threshold requirement, is that you need to show that you have either an advanced degree or its equivalent. So that means advanced means a master's or higher degree, or a bachelor's degree plus 5 years of post-baccalaureate progressive work experience in the profession. So anything that kind of happened before before you got your degree, before you got your bachelor's, that's not what they're looking at. They want to see you got the bachelor's and then you had work experience that occurred afterwards.
Quick question here. Someone sent a question. So what if someone has a bachelor's degree, and how can this person show the progressive work experience to qualify?
Sure. So the way that you show progressive work experience is through employer letters. So that can be if it's a current employer, your current employer, and then any former employers. So they need to, write a letter that is, detailed enough to show that your work experience, where it started, what the job title was, what the dates of employment were, and then what you worked on. And ideally, those letters should show a progression to show that your work experience progressed in your profession over the 5 years. Something that you can also do, sometimes you worked for an employer, that company no longer exists, or their policy is that they'll only provide, something that says so-and-so worked here in this job for these dates. So if that's the company's policy, usually what we recommend is that you reach out to your former supervisors, because they, even if they've left the company, if they're able to speak to that experience that you had and provide that detail, you can provide that along with the letter from the employer's HR department. Perfect. So, so if you don't have this degree and you don't have, the bachelor's degree, then what you can do is you can try to apply under something called exceptional ability. So you show that you have exceptional ability in the sciences, arts, or business. The way that you do that is you have to meet at least 3 of 7 criteria. So I'm not going to read all the criteria. They're listed on the slide, and as Ian said, they'll be available to you after, after the webinar. We'll send this to you. But you want to meet as many of the criteria as possible. So 3 is the minimum, but as many as you meet is better. And then you want to keep in mind that it's not enough to just meet the objective criteria. The way that they assess exceptional ability is a 2-part test. So one is, did you actually, meet the criteria? So it says, letters documenting 10 years of full-time experience. So did you provide those letters? That's going to be the first part of the analysis. Do you have letters that show you have 10 years of experience? The second part of the analysis is more holistic, what they call a final merits determination, where they'll look and say, well, but did those 10 years of experience and do these letters show this person has really attained a degree of expertise above what is ordinarily encountered in this particular field? It's obviously it's a good place to start seeing, do I meet these criteria? But then you need to think beyond that to, how do I show that not just that I meet the criteria, but that the criteria demonstrates, my level of expertise and that it's above others.
Perfect. Kelly, oh, sorry, go ahead, Michaela.
Quick question here. Is the exceptional ability standard the same standard that is used for the EB-1A green card?
So it's not. They're similar. So they are similar in the sense that, exceptional ability, extraordinary ability. Exceptional ability is a lower standard. So what they're looking at is, do you have a degree of expertise above what's ordinarily encountered in your field? In contrast, extraordinary ability is a much higher standard. That means a level of expertise, meaning you're one of a small percentage that has risen to the very, very top of your field. So it's, exceptional ability is going to be a lower standard. The NIW can be a good, a good category for people that maybe have looked at an EB-1A and feel that they're not quite there yet, may be able to meet the exceptional ability standard. However, the 2-part test is the same for both exceptional and extraordinary ability. So you're still looking at, objectively, do you meet what the criteria are? And second, looking at it holistically, are you proving that you either have expertise above the norm, or for extraordinary ability that you've risen to the very top of your field?
Perfect. And Kelly, one question I had, it's actually a question that's in the question answer, but I want to ask the question slightly differently to drive home a point that you're making with respect to the either or of these. So this is a lawyer, so it's a lawyer, and they're asking about the experience requirement for the threshold. And how it is they prove that, because they're in a situation where they are doing things where they're not on court records, but how they prove that. But also, if you could just comment on whether they even have to prove it in this case, because the person obviously is a lawyer and means they have a JD or a master's degree.
Right. So it's definitely an either or. So if you have a master's degree or higher, in some countries, a law degree is not a master's degree. It's an initial degree. So that is something you'd have to look at. You could get a foreign credentials evaluation to say, if you have a foreign degree, in some countries, in the United States, the way that it works is you have a bachelor's degree, then you go on to a master's or a Juris Doctor in the law. In some countries, you just have a law degree. If that was evaluated to be equivalent to a U.S. advanced degree, then you would not need to meet the exceptional ability. So you wouldn't have to prove any work experience for this threshold requirement. All the proof that you would need if you have an advanced degree is your diploma and your transcripts. So the easiest way I would say to qualify for this threshold requirement is if you have a master's or higher, because all you're submitting is a diploma and your transcripts. I think someone also asked, is it better to have an MBA, rather than a bachelor's with 5 years of experience? I think the MBA is easier to prove. It's more objective. All you're submitting is the diploma and the transcripts. If you're doing the bachelor's, then you have to get those employer experience letters, and the argument of whether experience is really progressive work experience adds some subjectivity into it. So I think if you have the master's, that's going to be the easiest way or a higher, that's going to be the easiest way to qualify under this category. Perfect. So once you've met that threshold requirement, The second step is to demonstrate that you qualify for the national interest waiver. So in a normal situation, you've met the threshold requirement, you have a job offer from a US employer, and now they're going to test the labor market to see if there's any US workers. For the national interest waiver, instead, what you're going to do is you're going to say, I qualify for a waiver of the job offer and the labor certification. And what you need to prove is 3 prongs. So one is that your proposed endeavor, so what you plan to do in the United States, has substantial merit and national importance to the United States. The second is that you're well positioned to advance that endeavor. And the third is that on balance, it's beneficial to the United States to waive the requirements of the job offer and the labor certification. The first prong is really focusing on what do you plan to do in the United States? Why is it important to the US? Like, what can we connect it to that that shows this greater importance, and how it will help? Will it help the US, kind of become more competitive in a particular sector? Does it deal with something important like, that's a social good, like veterans issues? Is it something that's going to speak to job creation? So all those things, anything you can bring in to explain why, why what you're working on or what you plan to work on is going to have substantial merit and national importance to the US, you want to bring in here. The second prong is really about you as the individual. Why are you well positioned to advance this endeavor? So any, your resume, your degrees, any past history of success, all those things are very important there. And then for the last one, there's a few different approaches you can take. We'll talk more about them, later in the presentation. But really you're showing that either the labor certification process isn't practical for you, it doesn't work for you. That's something that's often brought in for entrepreneurs. It can also, you can also argue that the good that you're serving is so good that you don't need the labor certification, because even if other people are working on this, it's, the level of expertise that you're bringing to it and the level of importance it has means that it's good that you are also working on it, or it's worth it to waive the labor certification. So those are some of the arguments you can use to show that the labor certification is not necessary. You can also argue that the issue you're working on is so urgent that, again, you should waive the labor certification. So sometimes, researchers who are working on breakthroughs, medical breakthroughs, technological breakthroughs, those types of things can qualify.
Really, and could you provide an example of applicant who kind of like met all 3 criteria?
Sure, and we'll go over one later as well, but this I'll present as a different one. One example is there's an engineer who is going to run a consulting firm working on kind of technology management and workplace consulting, and had developed a patent to help small and mid-sized businesses automate and optimize their profitability without losing any jobs. So an ability to kind of retrain US workers to do these jobs while also automating to stay up to date with the latest technology. So on the proving substantial merit and national importance, this hit many prongs. So one is preventing job loss. There's been a lot of kind of information in the media and the news about the fear of automation. How will technology displace workers? So this person, their business specifically dealt with that issue. Also staying competitive, so staying technologically competitive. And then also as well, because it was a business hiring US workers. So it hit several areas of substantial merit and national importance. In terms of being well positioned to advance the endeavor, the applicant had 30 to 40 years of experience in relevant fields, had letters from past employers attesting to kind of, things they had done, accomplishments they had achieved, and also had letters from, people that were interested in working with them now. So potential, business partners who said, I've spoken to this person, what they're doing is very important for the US. And the people they got the letters from were very, accomplished in their field. So that helped to show the person was well positioned to advance the endeavor. And then on balance, showing it would be beneficial to the US because this person was an entrepreneur running a company. A labor certification is not appropriate for them. If you're the full, majority owner of a company, you cannot get a labor certification for that. Additionally, the skills that he had were not easily translated into a labor certification. And then, the other part was the issue he was, addressing was so urgent, preventing job loss, preventing worker displacement, and hiring US workers, that it was beneficial to the US, even if other people were going to be working on something similar.
Thank you.
Thanks. All right. So how can the national interest be used for entrepreneurs? It was, I think in 2016, the standard for the national interest waiver changed. And when it changed greatly in favor of entrepreneurs. And as Ian mentioned, it's been kind of underutilized for entrepreneurs since then. So this is, one of the reasons we wanted to speak about it, to show that it's really a good category for entrepreneurs. So some of the things that this new standard was based on a case called Matter of Janazar. And in that case, they actually highlighted several things that are worth looking at to see why this is such a good category for entrepreneurs. So one is that they specified that when you're proving the prong of substantial merit and national importance, something can be of national importance, even if it's not geographically, doesn't have a huge geographic breadth. So that means that benefits to the US interest can also be local. And hiring employees in a local area, for example, an area with chronic underemployment or an economically depressed area, that could help, that's something that is of national importance, even though it's limited to a specific area. Similarly, if you have a company that has developed a really specialized product that has kind of really local impact, but the impacts are very strong, these types of things could still satisfy the national importance prong, even though they don't necessarily span a huge area across the United States. Another thing that they mentioned in Janazar is that, that this is a good category for entrepreneurs because, entrepreneurs cannot get the labor certification. It's either impractical or impossible for them to obtain it because of the way the labor certification process is structured. So if you do have majority ownership in a company, they don't believe that there's really a bona fide job opportunity open to US workers, which makes sense. But it does mean that entrepreneurs are really cut out of using the labor certification process, even though they're doing something of substantial merit and national importance. So in that way, they're able to show that on balance, it's beneficial to waive the requirements of the job offer and labor certification. So that's another way that Janazar, was basically saying that entrepreneurs are tailor-made for this category. And lastly, they specifically note that, entrepreneurial work can lead to a national interest waiver, and they state that the planned venture does not need to ultimately succeed, as long as the applicant can show they're well positioned to advance the endeavor, and it's more likely than not to proceed. So it's a preponderance of the evidence standard. We'll talk about that a little bit more, but that ability to show that you have a venture that you're planning, but you don't actually have to show that it has already succeeded at the time that you submit your application.
Kelly, and so when someone has a company in the US and they want to apply for the NIW, does the company need to be kind of like a large established company, or can it be a startup? And what are kind of advantages and disadvantages of startup versus established company?
Sure. So, you do not need to have an established company. For an NIW, it is possible to apply with a startup. In Janazar, as mentioned here, they explicitly acknowledge that some entrepreneurial ventures may fail, and the applicant doesn't have to show that it's more likely than not to succeed. So you don't have to submit an application that says this company has already succeeded. In terms of the pros and cons, the applying with an established company can be helpful because then you can show there's a track record of success. It also speaks to the second prong, where you can say, I'm well positioned to advance this endeavor because look what I've already accomplished. I've already hired workers. I've already kind of advanced, US national interests. Here's how I've done so. So having an established company that has lots of workers, I think obviously it can, strengthen the application. A con of an established company is that if it's not doing well, like let's say you've been running the company for a few years and it's not not actually, it hasn't been successful yet, you're going to have a harder time convincing them, that this venture is ultimately going to do what you say it's going to do. Whereas for startups, the benefit that you have is, you can rely on a kind of a strong business plan. You should have a track record of success in the industry, but it doesn't need to be with this particular company. So if you have been, really successful in the industry and other ventures, and now you're starting up this new venture, a startup does give you, nothing has happened yet. So you have more to prove in your business plan, but you also don't need to work against any poor performance. So those are kind of the pros and cons of established versus startup.
Okay, thank you.
All right. So timing and other considerations, when moving from a non-immigrant visa to an immigrant visa. So I'm just looking at the questions. So, in terms of timing, there is no premium processing available for the National Interest Waiver. That means that premium processing is where you can pay the government an additional fee and they will process an application within 15 calendar days. This is not yet available for the National Interest Waiver. It may become available, over time, but right now it's not. That means that it could be pending for several months. Processing times change all the time, but right now, some service centers are processing these in 6 months. Some are taking 12 to 14 months. So there is some variability, in the timing when you're planning for that. You also want to consider your underlying visa status. So some visas, like the H-1B and the L, allow for something called dual intent. That means you can file an immigrant petition and it really doesn't have any impact on your ability to renew the visa or on your ability to travel. If you're on a non-immigrant visa that doesn't allow for that dual intent, so some examples we've given are the TN or the E1, E2, E3. Once you file the I-140, it becomes more difficult to renew that underlying visa. So you want to just be thinking about, when does my current visa expire, and what do I want to, how do I want to plan, moving forward for, wherever I'm working now, and how is this national interest, waiver application going to work into my plans. The E1, E2, E3 visas have a little bit more leeway, like just filing an I-140 by itself is not going to necessarily prevent you from renewing those visas, but it is something you want to discuss with your immigration counsel because, depending on your timeline for renewal and how strong your ties are to your home country, you just want to keep it in mind when you are planning for when to file.
Kelly, quick question here. So does filing the I-140 kind of give you any status in the US? So let's say someone's status is expiring, like E2 status is expiring in May, and the I-140 is filed, in April or May. Does the filing give you any status in the US, and can you stay in the US?
It doesn't, yeah. So the I-140 doesn't give you any status. By itself, it doesn't give you any ability to stay in the US. So we'll talk about the application process in a minute, but yeah, if you're in a position where, all you're filing is the I-140, that provides you with no underlying immigration status. So you would need to continue to maintain your non-immigrant status if you wanted to stay in the United States. So in terms of the application process, you submit the I-140 with proof that you meet the EB2 qualifications. And then if there's an immigrant visa available to you, so if your category is what we call current, you may also be able to file an I-485 green card petition. So this is available to people who are in the United States in a valid status. They can file the I-140, and the I-485 concurrently. You can also, if you're outside the United States, you can file the I-140, and then you can consular process abroad. So those are the two options available to you. The I-485, the going over the pros and cons, the benefit of adjusting status from within the US is that, you can remain here for the entire time that the application is pending. You can apply for, work and travel authorizations, so you don't have to maintain that underlying status anymore. You may want to. There are reasons why people do want to. For example, if the petition is denied for any reason, it can be beneficial to have that underlying status to fall back on. but many people, for whatever reason are not able to. And so adjusting status does give you that ability to stay in the US and continue to renew your work and travel authorization until your green card is granted. Versus consular processing, if for whatever reason it's more convenient for you to live primarily abroad, while you're waiting for your green card. Previously also, consular processing could be a bit faster. Unfortunately, given COVID, that's no longer the case. And there's extreme, there's long timelines from within the United States, up to kind of maybe even a couple years. But that's unfortunately now the same situation with consular processing because of COVID.
Kellyanne, can any family members apply for the green card as well with the main applicant?
They can. So your spouse and any children under 21 are able to apply with you for the green card. When you submit your I-485 application or your consular processing application, they can submit documents with you.
Okay, perfect.
All right. So what do you include in a national interest waiver submission? So in terms of the actual documents you're going to be submitting, the first is proof that you meet one of the threshold requirements. So as we discussed, the easiest way to qualify is having that advanced degree. It's just your degree and your transcripts. So very straightforward. If you're qualifying with the bachelor's, your degree, your transcripts, the 5 years of progressive experience. And then if you're applying for exceptional ability, you can anticipate that it's going to be a more onerous documentation requirement. You're going to show that you meet at least 3 of the 7 criteria and ideally more. But again, it's not enough to just meet the requirement. You can't just show membership in a professional organization. You also need to show how that membership proves that you have expertise above the norm. So you want to be submitting kind of as much as possible to show that you meet that exceptional ability criteria. Then you're going to look at your national interest waiver requirements. So, to prove that you meet the 3 prongs, you're going to submit documents such as news articles, academic papers, market research, relevant data. And the purpose of submitting those documents is really to show that your endeavor has substantial merit and national importance. So these can be very compelling. If your issue, the thing that you're addressing or that your company is addressing is something that is, talked about in the media all the time, widely acknowledged in the United States as having, kind of relevance and importance, that's something you really want to highlight. And that objective, obviously you can, submit expert letters, which are very important as well, but that objective, evidence, I think is also really important. Just to prove that your proposed endeavor does have that merit and importance. For entrepreneurs, you also want to submit a comprehensive business plan. The business plan is very important to show that you can meet, that you're more likely than not to succeed in this venture. So especially for a business that's a startup, that's really going to be a key document. Other things that you can submit would be expert letters. So these letters can be used for a few different things. One is to demonstrate, substantial merit and national importance. So if you have an industry expert who is saying to you, or saying in the letter, the thing this person is addressing is an urgent matter. I've worked in this field for 40 years, and this is something that we're seeing as really, really important, then, that can be really helpful. And the other thing that the expert letters do is they can show that you, as the applicant, are well positioned to advance the endeavor. So if they've worked with you in the past, or if they haven't worked with you, but they've encountered your research, encountered your, your work, that's really important as well to say, I ran across this person, we're very impressed by the work they're doing. So you can have a couple different types of expert letters, speaking to different parts of the, of the national interest waiver prongs. Another thing that you're going to submit, sorry?
Question here. Someone is asking if they can use all the recommendation letters from different visa applications.
So generally, no. We generally do not recommend that. The reason being that expert letters are really not recommendation letters. Very often recommendation letters will be written saying, this person had like the language that they use, even if it's, strong or good language, might be a little bit too tepid for what's really required for these expert letters. So even though those might be a good jumping off point, and the writers of those letters may be people that you ultimately do want to have write your letters, you really probably will need to have them redrafted with the national interest waiver in mind, just given that they aren't recommendation letters. They're really letters that are speaking to these specific requirements.
Okay. And then another question was, what should generally be in the expert letters?
So, the expert letters should speak to your contributions to the field and the importance of your proposed endeavor. In terms of the content, they should contain a description of the expert's relationship to you. So how do they know you? Did you work together? Did they run across your work in some other way? A description of your professional history, a description of the impressive contributions you've made to your field. They should mention any prizes or awards that you've won, any very impressive or influential publications, any business success you've had, if you've participated on prestigious panels, if you've done any groundbreaking research. All of that should ideally be in the expert letters, as well as any background information that they can provide on your field of endeavor and why it has substantial merit and national importance. And as I said, the letters can kind of speak to different things. You may have one letter that's from an expert that has worked with you and they really can speak to your accomplishments and why you are well positioned to advance an endeavor. You may have another expert that, has maybe seen your business proposal and can speak to that. And their real purpose of that letter is going to be not only speaking about they're impressed with you, but also really bringing their expertise to bear to say, this endeavor has substantial merit and national importance. So you want to think about how you're using the letters because they can stand for different things.
Thank you.
Perfect. So the other, thing you'll provide are, kind of your resume and degrees, proof of your professional accomplishments. So things that are mentioned in the letters, you're going to include the objective evidence to support those things. So if you have awards, if you have patents, if you've presented at conferences, if you had industry or media recognition, all of that can go in there. And, you want to, so this may also cross over a bit with the exceptional ability. If you had to prove you had exceptional ability, some of that information in that section might be relevant as well to show that you are well positioned to advance the endeavor. Additionally, for entrepreneurs, you can include not just a business plan, but proof of contracts. If you have letters of intent, from people that want to work with you, if this is a startup. Also, if you have startup capital, to show that your company is likely to succeed and that you're going to be well funded, that can be mentioned in the business plan, and you can also provide that, that information separately.
Quick question. Someone was asking, how long does it usually take to put together the NIW application?
So the NIW application, it can take, a few weeks, or I'd say, a few months in terms of actually putting it together. You as the applicant do need to gather a lot of documentation. So if you're proving exceptional ability, for example, some of that's going to be, more onerous to gather. But generally they are, as you can see from this list of what's, what to submit, they're quite document intensive, cases. There's something that, you do have to kind of be able to pull together a lot of documents to support each aspect, of the, that is required. So it does depend on how quickly the applicant's able to do that. But generally, I'd say it's a process that takes, weeks or months, depending on the applicant.
Okay, perfect.
All right, so let us move to the NIW case study for entrepreneurs. So earlier we kind of went over quickly, one potential, avenue for an entrepreneur, and we'll talk about a different one now. So in this case study, this applicant was an entrepreneur who formed a small consulting firm to work on projects focused on improving services to U.S. veterans. For the substantial merit and the national importance prong, they submitted expert letters, news and media articles, research reports, These objective supporting documents outlined a lot of difficulties faced by returning veterans from Iraq and Afghanistan, and showed the value and importance of providing services to these veterans. So that was kind of the substantial merit piece. This section was also supported by the expert letters. Expert letters were submitted by leaders in military, government, business and charitable institutions, as well as that objective news evidence, news media and articles, and evidence of the government's own initiatives in this area, showing that this is an area of national importance. This is an area the US is focused on. So although this was an entrepreneur, they also had this, it was actually the substance of what they were doing that was really focused on, to show that it had a substantial merit and national importance. Speaking to why this person was well positioned to advance the proposed endeavor, the expert letters were also utilized in this section. So not only did these letters speak to why this initiative was so important, but they also spoke to this particular person's prior success in working on these issues. What had he done in the past and why was it so successful? So, having experts in the field that are willing to attest to that success, and explain why it's so important was really key. Additionally, he offered a comprehensive business plan, business plan including detailed financial assumptions, explaining exactly how he was going to accomplish all the things that he said he was going to accomplish. Who are my clients? How am I going to market myself? As well as proof from, kind of prospective clients saying, hey, we really want to work with this person. And then he also submitted financial statements, so showing it was really a financially viable, enterprise, and that they had startup money to accomplish what was outlined in that business plan. And then on balance, that it was beneficial to the US to waive the requirement of the job offer. You really want to kind of meet as many of these options as possible. So he argued that not only would it have been impractical to obtain the labor certification since he was a majority owner, but then additionally, even if other people were working on this area, the value that he could provide, his track record of success, meant that even if other US workers could provide these services, the US was still going to greatly benefit from the contributions that he could provide, as proven by all the evidence that we just discussed.
A quick question here, Kelly. So what can entrepreneurs generally do to kind of strengthen their NIW case?
So entrepreneurs, I think, one place to start is you want to have a strong business plan. So, if you have an established company, obviously look at what you've already accomplished. If you have a startup, definitely, make sure that you yourself or you're working with, kind of professionals who can assist you in drafting a business plan that hits all those marks that are mentioned. So, marketing, client prospects, financials, what services exactly are you going to offer? It should be a really robust business plan. Having evidence of startup funding. So either your own funding, or if you've been able to attract investors, that can be very helpful to show that your business idea is one that is being valued and viewed as, as valuable and lucrative. If you have any large contracts that you've been able to secure, those types of things can be very helpful. Letters from industry experts, and not just, as you see from this example, it's not just kind of people that only worked in veteran services, right? It's people kind of from a wide range of fields. So people in the military, people in the government, but also businesses, philanthropic, institutions. So the more people that, are related to the industry that can explain why what you're doing has substantial merit and national importance, that's very helpful. As well as, kind of any lucrative business partnerships. So if not, going beyond clients, but, other businesses that perhaps are doing what you're doing, or doing something similar or parallel to what you're doing and are interested in working with you, those can be very helpful. And then finally, also, you as the entrepreneur want to show that you have a track record of success in this field. So, if even if you haven't been running this business for a while, if you have run other successful businesses, or if you have been in a management or leadership position in other businesses in this area, you really want to highlight that as well.
Thank you. Perfect. So let's see if we have any other questions we didn't go through. So So Kelly, someone is asking if the degree has to be relevant to the proposed work. Like the person has a master's degree, but in an unrelated field.
So, I mean, I think, I think generally the master's degree needs to be related. It doesn't have to be, I have an MBA and I'm running a business, but there should be a tie-in between what the degree is and what the proposed endeavor is. It's not 100% that is it may, like, sometimes you can kind of creatively tie the degree to what you're working on, especially because entrepreneurialism can be a very broad field. But generally, if it's in an entirely unrelated field that has nothing to do with what your proposed endeavor is, I think that's going to be a challenging national interest waiver case.
Then someone is asking, as a foreign attorney, does admission to a U.S. bar alone suffice to show that you are well positioned to advance the endeavor?
So I think no. Yeah, I think you would definitely need more than that. Again, it depends what is the endeavor, right? So I don't know if, like, let's just say as an example, if the endeavor was a law firm, just showing that you have the baseline requirement to run, to be able to run a law firm is not really going to be sufficient. They are looking for kind of a history of success. And national interest waiver applicants, because you're asking them to do something special in waiving these normal requirements, you really want to show that, like, let's say the person had the US bar and then proof that they had successfully had a leadership position in a law firm that had been extremely successful, in another country. That's kind of more along the lines of the type of thing you need to provide.
Okay. Then another question is, in making the NIW application, will I be required to attend interview at the US Embassy abroad, or is the process kind of through USCIS?
So it depends on, with the I-140, which is the national interest waiver part of the application, that's solely done through USCIS. So you submit an I-140, you submit the supporting documents, USCIS alone is going to look at that. Once you get to the second step, which is where you get your green card, if you're in the United States, then it's going to go through USCIS. You often will have to attend an appointment with USCIS in the United States. If you are applying for your green card abroad, if you're not physically in the US or you want to go to a consulate for some reason, then you would go to the consulate and you would attend an interview with the consulate.
Okay. Then another question is, I have not written any articles for publication, but I have been cited extensively in other kind of like court cases. Will those citations be sufficient, or do I actually have to publish articles for the NIW?
Yeah, so there's no requirement that you publish articles. I think that there's not a specific set of things. If you're not kind of looking at the exceptional ability, if you're looking at the national interest waiver, are you well positioned to advance the endeavor? Having publications is certainly helpful. Being cited to is certainly helpful. So anything that is, valuable to your case, you'll use. And the more that you have that shows this track record of success, you want to emphasize. But it's not a requirement that you have your own publications in order to get a national interest waiver. It's not one of the requirements.
Okay. Then another question is, how many expert letters will I need to submit?
So there's no required number. I'd say we usually kind of talk about, somewhere between 6 and 8 letters. I think that, really you want to think about what is the purpose of the letters. So if the letter, having too many letters can actually be detrimental, especially if the letters are from weaker, kind of letter writers. So I think even less than, like, let's say you had 4 really, really, high-ranking government official, a really well-recognized leader of industry, then maybe you only need 4 or 5 letters. So it really depends on kind of what other evidence can you provide and who are the letter writers, for your case.
Okay. Then the next question is, what are my chances for approval if I think this person is under E2 investor visa and there is no publication of national recognition.
Yeah, so again, you know, a written if we're talking about kind of like, do you need to have published, you know, to get the NIW? The answer is no. You know, in terms of, do you need to show that you have, you know, kind of achieved success? If you're here on an E2 and you want to get an NIW, you know, you would need to kind of go through each prong and see, do you meet each of these prongs? So is what you're working on, is your business, can you argue it's an area of substantial merit and national importance? You know, are you well positioned to advance the endeavor? So you certainly don't need to have a publication, or have published at all to, you know, to meet that standard, but you would need to show, that you had an impressive track record in other ways. So, you know, has your E2 company, you know, been thriving? Have the financials, you know, shown that you know, the financials have increased each year? Things like that.
Okay, sounds good. And I think that were all the questions that have been submitted. I think the other ones we kind of like answered throughout the presentation. So let me see.
I see one asking if the spouse of an E2 visa can apply for an NIW. And yeah, I mean, the answer is yes, if they meet the requirements. So, you know, if they meet the NIW requirements, you know, they certainly can submit an NIW application. Mhm.
Okay, perfect. So if anyone has any kind of last minute questions, feel free to submit them. But if not, as Ian mentioned, we'll kind of send links to all the materials, to the guide and to the webinar as well.
Perfect. Excellent. No, thank you very much. That was great. Great information. Thank you very much, Kelly. Thank you very much, Michaela.